Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, in Connecticut, what is the difference between a divorce, a legal separation, and an annulment?
So in Connecticut, there are three different mechanisms to end a marriage under the law. And this is separate and apart from the religious process of annulment. That has nothing to do with exactly the processes that are available under Connecticut state law. So the dissolution of marriage process is Connecticut's term for a divorce. That happens when two people who have been legally married either in Connecticut or elsewhere, and one of them wants to go through the court process to end the marriage. In the context of a divorce proceeding, the court has the authority to issue orders about division of property, alimony, child custody, visitation, and name change, restoring a maiden name, for example. Legal separation, on the other hand, is slightly different. This is a court order that's issued that relates to two people who are remaining legally married even after the court order. The court can make similar orders in a legal separation action about property and alimony and child support and child custody. But after those orders are issued, the people who are the subject of those orders remain married. And this is usually done for religious reasons, where people, for whatever reason, intend to live separately and permanently, but they do not want to be divorced. The other difference with a legal separation as compared to a divorce is that neither party in a legal separation after the judgment can be remarried. Usually we hear people ask about the question of legal separation when they're unsure if they want to be divorced, but they do want to live separately for one reason or another. What they often don't understand is that legal separation requires much of the same process that a divorce does. It still requires a summons and complaint. It still requires a court action. It still requires certain financial disclosure and the development of a parenting plan and a finding by the court of best interests of the children, and that the division of all the property in that legal separation is fair and equitable to both parties. It certainly requires approval by a judge. So usually that's a little more intensive than the person might have envisioned when they asked about a legal separation. And obviously people can go about and live separately and work on the marriage or not work on the marriage without an order of legal separation. There is a relatively simple process where after a legal separation can be converted to a divorce or a dissolution of marriage. And also, this is very important, where one party at the beginning of an action asks for a legal separation and the other wants a divorce, the court will order a divorce or a dissolution of the marriage. Annulment is the third process, the third legal process, after which a marriage will be terminated. And in that particular instance, a court is declaring that the marriage essentially never took place to begin with. It never existed. The term is void ab initio, which means that it's voided, the marriage is voided from the beginning. A short marriage, this is a misconception, a short marriage doesn't automatically guarantee that annulment would be granted. It's usually only possible when the marriage was not legal in the first place. Either one party was underage, for example, or one of the parties was already married, whether they knew that or not. There are other legal claims that could form the basis for an annulment, such as fraud or essentially a contract where the parties had a fundamental misunderstanding as to what the terms would be. So in determining whether a marriage is voidable from the beginning, whether we should go back in time and essentially declare that the marriage never existed, the court is concerned with those incidents leading up to the marriage ceremony itself and surrounding the ceremony. In order to determine the state of mind and the intention of the parties when they entered into the contract of marriage, this type of analysis is important. So to determine whether your marriage qualifies for an annulment, or if you have further questions about the legal separation or dissolution of marriage process, you certainly should seek counsel of an experienced Connecticut family law attorney.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.